Former Vice President Atiku Abubakar files appeal as Supreme Court seeks nullification of tribunal judgment. Alleged fund diversion, Governor Abiodun calls for discipline in APC, says is ready to defend himself. And court dismisses Bokachawa's suit seeking to stop ICPC from probing him over his statements. And outside of Nigeria, reported clashes in Port Sudan. And 3 Ghanaians to be charged over pro-Wagner rally. Tonight in Politics HQ, I will be talking to Barrister Monday Ubani, Chairman of the Nigerian Bar Association Section on Public and Development Law. I am Gbenga Aborowa. Stay with us. Politics HQ. We'll be right back. Now, politics tonight begins with the former Vice President of Nigeria and presidential candidate of the People's Democratic Party, Atiku Abubakar, who has filed an appeal at the Supreme Court following his loss at the Presidential Tribunal. Atiku alleged a miscarriage of justice by the tribunal, which awards the Court of Appeal and expects the apex court, the Supreme Court, to be more proficient and patient in its judgment. Former Vice President Alhaji Atiku Abubakar also filed a petition at the Supreme Court in 2019 after losing the presidential election to former President Muhammadu Buhari. The Supreme Court is expected to deliver judgment in the coming weeks. Now, joining me tonight in Politics HQ to discuss this is Barrister Monday Ubani, Chairman, Nigerian Bar Association Section and Public and Development Law. One welcome to you, Barrister Ubani, and thanks for joining us in Politics HQ tonight.
Yeah, thank you for having me. Of course, I was a former chairman. I've just handed over 2 months ago to a new chairman. Yeah, thank you very much.
Thank you and congratulations. Now, Barrister Ubani, could you elaborate on the specific grounds of appeal that Alhaji Abubakar Atiku has lodged before the Supreme Court, and how these grounds challenge the Court of Appeal's judgment in detail?
Yeah, thank you very much. When your television informed me of the appeal, which is a breaking news, I went over to the internet in order to search to see what grounds were filed by Atiku's counsels with regards to the decision of the Court of Appeal, the tribunal that handled the presidential election. I discovered that the reportage was also very scanty as to the grounds, but certainly those papers, both Vanguard and Punch, made reference to issue of the fact that he has appealed alleging misdirection in law and fact, which has occasioned miscarriage of justice, and that justice was not served by the decision of the 5-man panel, generally. And so they want the Supreme Court to review some of the decisions that have been taken by the Court of Appeal that handled the presidential election. If you ask me, I'm sure they will be appealing on the ground of the fact that the court below excluded a lot of vital witnesses that were not allowed their evidence. The evidence written statement on oath were not allowed on the ground that they were subpoenaed witnesses whose evidence supposed to have been filed from beginning of the petition. I know that would be a ground of appeal. I am also too very sure that the issue of INEC not following its guidelines with the issue of transmission of the election results from the polling units to the IRF will form a very good ground of appeal for them because they complain about that particular aspect of that decision. I'm also too very sure that the issue of Abuja, the status of Abuja, whether it is very important and relevant with regards to emergence of the president in Nigeria, will also form the fulcrum of the appeal. And so by and large, the issue of Abuja, the issue of witness statement that we excluded, some of the witnesses that we excluded, the issue of INEC not following its own rules, and some other decisions of the court will be a ground of appeal, which they will want the Supreme Court once again to take a second look at.
Now, Barrister Ubani, looking at antecedents and the history of this sort of cases in Nigeria, it's not the first time that presidential elections will be contested. Could you shed light on the Supreme Court's historical role in election-related cases in Nigeria at the presidential level and discuss the factors that justices typically consider when reviewing appeals of this nature?
Well, the Supreme Court, if you remember from 1999, has been looking at election petition. I think it's only once from 1999 to date that the Supreme Court has not been called upon to look at the issue of
When
presidential
President
election.
Jonathan congratulated former President Buhari.
That is correct. That is correct. And that was in 2015. Every other year, we conducted election in Nigeria has always seen the presidential aspirants who have lost going as far as to Supreme Court. And the Supreme Court has maintained a very stoic, balance in not really acceding to nullify any of the results so far. 1999, it was contested. 2003, it was contested. 2007, which was regarded as the worst election in Nigerian political history, went as far as the Supreme Court, where they had a split decision of 4-3, where Buhari was the one that actually the appellant at the Supreme Court level. And the Supreme Court held that the election, despite some of the irregularities that were found, were not valid enough to nullify the presidential election. That of 2011 was also contested, except 2015. 2019 went out of Supreme Court. So Supreme Court has never, Supreme Court of Nigeria has never nullified any of the presidential elections that have been brought before, despite the pointing out some of the irregularities. As I said earlier, 2007 election was the worst. If you Google internet, you will never see the result of 2007 general election.
Sorry to interrupt you, President Jonathan at the floor, and it's former President Shehu Musa Yaradua at the floor of the United Nations General Assembly, which coincidentally is happening now, did say, and he raised up his hands to say that, you know, the elections that brought me into power, into office, were deeply flawed, and I'm going to do something about reforming the Nigerian electoral system.
That's correct. The president himself that was declared the winner actually owned up and agreed that that election was the most flawed. But guess what? The Supreme Court validated that election and found that the allegations against it were not substantial enough to lead to this issue of nullification. So it then means that the Supreme Court will always take into consideration the issue of other like political consideration may come in. The issue of cost of doing another election may be an issue. I'm sorry that we have an issue of light.
It's fine. It's fine. We have your audio, so we're good.
Yeah. Yes, NEPA has just come. I mean, PSN has just come back. I'm very sorry about that. And so, despite the allegation of very, very major irregularities in the electoral process of 2007, the Supreme Court was of the firm view that, look, there is nothing that was substantial enough to lead to nullification. So there may be some other, as issue of cost, issue of running another election may be an issue. Issue of nullifying election that probably the president himself have been sworn in and have taken position and have tried to act, and maybe has presented budget and the budget passed, and you now want probably to take him out and all that. It's a consideration.
Barrister Ubani, whose side does the burden of proof fall on?
Yeah, the burden of proof in election petition is very heavy on the petitioner, and that is the issue. Because you have to present all the witnesses that are vital, especially when you make allegation of irregularities or non-compliance with the issue of electoral act or the constitution, if that is the ground of the allegation. Those irregularities usually emerge at the polling unit. So you must present all the polling unit agents in order to prove. So the burden of proof in election matter is very heavy upon the petitioner. And so if you are not ready to get all the witnesses within the limited time allocated to you by the court to prove those facts, you will run into problem in convincing the court to nullify an election that has been held and then a valid winner declared by INEC. So it's a very heavy burden. So what I'm trying to say in effect is that in our electoral jurisprudence, may we now begin to look at the issue of not allowing those whose election is being challenged to be sworn in. We have to exhaust all the processes, including court decision, which is final, before you can now say, oh, this person should be sworn in. Because the moment you swear in an individual who now uses apparatus of state and all, it will be difficult to ask that person who has already been sworn in to leave power. Because you create a vacuum, create all manner of economic problem, create a lot of political problem and all that. So it is something that we have to take a second look at, from now onwards, because the burden that is placed on an individual who is challenging somebody who has been sworn in is a very heavy burden. It's not only contending with legal burden, it's also contending with issue of political burden, it's also contending with issue of cost. How are we going to nullify this election? And then where is the money to conduct another electoral process? And then all the problems and crises that comes with elections. So these things come into consideration. I can't rule it out because we are living in an environment that is clearly unstable. So I'm saying, let's begin to look at our electoral laws once again. And one of the recommendations will be, before you swear in an individual whose election is being challenged, let it be exhausted at the judicial level before you swear that person in, then also reduce the burden that is placed upon the petitioner. It's a very heavy burden. I had thought with the Electoral Act of 2022 that burden would have been lessened, especially with the novel provision of Section 137 that says documentary evidence now can be relied upon and can be given at the bar. Even you can tender that evidence at the bar, and the court will be bound to look at those documentary evidence. But we see in that decision that has just been rendered recently that they are still saying that you can't come and dump. You still have to produce witnesses that will come and speak to those documents you are dumping and all that. So we are still back to square one. So we need to really be looking at our laws and then getting the spirit of justice is also to align with the current spirit of the new amendments is very key.
Now, finally, Barrister Ubani, just last night on the same program, I did have the pleasure of speaking with the Senior Advocate of Nigeria, Mr. Femi Falana, who echoed the same sentiments you just shared on the program tonight about the timing. And he says, it would be nice for this election petition tribunal to conclude its case and give a definite judgment before any swearing in is done. Now, having said that, beyond the specifics of this case, Mr. Falana also said that, it's not the duty of the courts to decide who wins elections. It's INEC. Now, beyond the specifics of this case, can you provide insights into how election disputes and legal battles of this nature impact the democratic process and the rule of law in Nigeria? And what potential ramifications might there be for future elections in the country?
The point is that democracy entails a choice of the majority about those who governs them. And we must take a look at our electoral process and then ensure the fairness of that process and ensure credibility. And that's why we are suggesting that we must digitize our electoral process, to really dissuade the issue of human interference that most of the time tinker and and give a bad reputation to our electoral process. Most times it is at the polling unit that you usually have some problems. But we are now beginning to see that another angle of our electoral problem, stems also from the collation. After the election has been held successfully at the polling unit, by the time you now carry the result to the collation center, you now begin to see the manipulation that comes along with it. And that's why those CSOs, I'm talking about civil society groups and some lawyers and activists, insist that we must digitize our process. And that was the Electoral Act now talk about electronic transmission, that whenever you have announced the result at the polling unit, let it be transmitted immediately. So it ensures transparency and fairness. But we have seen what happened, with the election of 2023, that was not complied, especially with the presidential. So issue of choice of leadership, recruitment of leaders lies with the majority of the people. And we must try to create that fairness at the polling unit. But the moment you fail, you still, of course, the court has to come in. But court coming in is to now look at the entire process, whether they have complied with the laws and regulations. And if they have not complied, then you have to ask for a wrong. It's not for the court now to make that choice because the court remains a minority. is a court of either 7 or 5 or 3. So 3 and 5 and 7 cannot make a majority at any point in time. Rather, it is the millions of people that constitute majority, in any country. So
Yes.
it is important we create that fairness at the electoral polling unit, where we can decide who governs, and not at the judiciary, because judiciary at every point in time remains the minority. They can only look at the process. If it does not comply, ask for a wrong, but not for you now to now decide who becomes governor, who becomes the president. Yes.
Thank you very much, Barrister Mondu Ubani, former chairman, Nigerian Bar Association Section of Public and Development Law. Always a pleasure speaking to you on Politics HQ. We do appreciate your time and your contribution. Thank you.
It's my pleasure having me. Thank you very much.
Yes.